Good evening and namaste everyone. Welcome to our first global seminar jointly hosted by Area Financials PC and our Tulsian and Company. Today we are going to talk about US-India cross-border transactions. Before we begin, I would like to extend my warm welcome to each and every one of you who took a time out from your busy schedule to attend this seminar. I see some familiar faces and also a lot of new faces in the crowd. I hope to meet each and every one of you before the evening is over. I would also like to extend my thanks to friends and who are watching us live on the internet and not only from the different part of the US but all over the world. I hope you all find this seminar both helpful and informative. I'm going to introduce myself first. As you know, my name is Shashwat. I'm the founder, president of Area Financials. I'm a certified public accountant, and I have been practicing public accounting since 2002. I started AVR in 2006. Over the years, I have worked with thousands of clients all over the United States with variety of corporate and personal accounting and tax solutions. We specialize in providing tax and business advice to all different kinds of visa holders as well. As we promised, the next hour will be very informative and you will be very glad that you have attended this session. You will be taking a lot of valuable information with you when you leave here tonight. The main topics that we are going to cover tonight are capital gain taxation or potential double taxation, tax efficient strategies on investing in India, investment opportunities in India, voluntary disclosure programs, and foreign bank reporting issues and compliances. We will wrap up the presentation by 6:50 p.m. tonight, and we'll leave enough time at the end to answer your questions. So please wait till the end for any questions you might have. Write them down as we cover specific topics. We will try to answer as many questions we can as time allows. If you have any specific topic that we have not covered tonight, please contact myself or Shashwat so we can address any issues you might have. We will also email you a PDF copy of the presentation at the end of the seminar. Please make sure you have provided us your email address at the front desk. Now, I would like to introduce our business associate, Shashwat from India. Shashwat is a chartered accountant, lawyer, and company secretary. Recently, he was a guest speaker at TED Talk as well. Over the past few years, he has worked on more than 5,000 complex multidisciplinary projects for multinational companies globally. Our Tulsian Company is a six-decade multinational chartered accountancy and legal service firm based out of India. They provide full service such as taxation, accounting, auditing, international structuring, transactions, legal and outsourcing services. They operate in the US, UK, Middle East, Asia Pacific, and Pan-India. Now, I'm going to start talking and we'll give the floor to Shashwat, who will guide us through some of the topics that we have highlighted here. Now, please turn your cell phone either on the vibrate or silent mode. And welcome, Shashwat. Thank you.
Thank you, Rachna. Good evening, ladies and gentlemen. Namaste. Very good now. Thank you for being here. And thank you, everybody around the world who are watching us and joining us live. I feel a major responsibility towards the time that you've agreed to invest today here. And I hope our talk really adds some real value to you and your lives. So let's begin, shall we? So we'll start by discussing some important economic relationships between India and US and establish why this relationship is actually important and why should we discuss all the issues that we are going to discuss after this. So as you can probably see, India US have had, as you can probably see, India and US have had bilateral merchandise relationship during January to September last year for about $50 billion. US is the sixth largest source of FDI into India, and the total FDI that's flown from US to India from April 2000 to September 2014 is over 13 billion. Even Indian companies are very heavily invested in the US. As you can see, the Indian investments into the US has been to the tune of 17 billion. There are 3.5 million Indians living in the US, accounting for 1% of the total population. And of course, the cultural and social relations between India and US has never been better. So with this backdrop, let us discuss who would our issues be important to? Who should be concerned about all the issues that are going to be laid out and discussed today? A global citizen. I would like to think all of you here present and all of you watching globally are a global citizen. Had you not been so, you would not have been. So who would be a global citizen? We are going to very loosely define the term. Somebody who has income in multiple jurisdictions, somebody who has assets in multiple jurisdictions, or somebody who has economic interest in multiple jurisdictions, whether direct or indirect, would be a global citizen. So with the perks of being a global citizen comes the pains of being global citizen. So what are some of the major pains that we as global citizens face in our day-to-day lives? I think, and all of us can agree, the most crucial, the most important, and the most excruciating complication of being a global citizen is double taxation. Now, let me quickly just sort of explain how the double taxation infrastructure works globally. So, we have a resident country and a source country. A resident country, say for all of you, would be the US right now. So, the US would say that since you're living in my country, I'm giving you security, I'm giving you protection, so I have taxing rights over your income. And I'm going to tax you for whatever you earn in whichever part of the world you earn in. So in that sense, US taxes its residents on their global income. Now we talk about a source country. So source country would be a country from whose soil you're earning the money. So say you have a business which is based out of India. India would say, since you're earning money out of my soil, from my country, from my people, so I have the right to tax that part of the income that is accruing from my country. So here we have a case of double taxation where there's conflict of interest between two huge jurisdictions. So this is one complication that every global citizen has to face. The other is, of course, formalities. So with the increasing complexities in transactions around the world, the compliance burden on the client, on you as global citizens, have really increased. And these days, a cross compliance between two countries is a new emerging trend. We are going to cover some of the aspects of both double taxation as well as compliance. And of course, with all of this comes the time and effort that we need to invest into getting ourselves updated and also designing the business strategy by taking into consideration the taxation and the compliance burden. So what is the solution to all of this? I believe the key solution to all of these complications is self-education and awareness, which is why we are all here today and which is what we try to attempt to impart. So before I move to the next slide, let's talk a little bit about it. So I'm going to talk about one of the biggest issues that we all face. About 90% of our clients have at some point faced this issue, and it is one of the most pervasive issues that international taxation is incurred with. Double taxation burden. So we are going to talk specifically about the capital gains issue because it's a very major emerging challenge that people living in the US as well as India are facing. So if you closely watch the structure, let us take, for example, an American resident. It can be a company, individual, anybody. An American resident having a property in India, which can be real estate, which can be a financial asset, and subsequently sells off that asset. Some sort of capital gain accrues on the sale. And based on the source rules that we just discussed some time back, the country of India taxes that capital gains from the US entity. Now, as we again discussed, the US would extend its residential right and tax the global income, which would include the income in India that's accrued on which tax has been paid. So here is a classic case of double taxation, which is one of the biggest issues in capital gains, especially because the transaction value in capital gains is comparatively higher as compared to all the other sources of income. So India is taxing, US is taxing, everybody's taxing on the same income, which if you do some quick calculation can go up to 60% of the total income that you've actually earned from the transaction. This is quite inefficient. There has to be a better way, right? So the government of India and the government of US, like most of the jurisdictions, they would enter into a treaty whereby they would agree to grant deduction of the taxes paid in one country while taxing the other country. So for example, somebody in the US selling a property in India, the US government would say that it's okay, I will give you deduction for the taxes that you've paid in India by virtue of this treaty. It should be that simple, right? However, it's not. What we see is, and I'm now going into a little bit of technicality, is that even though the governments have agreed to give taxation credit, but there is a specific overriding provision that has been placed in the DTAA, which is the Double Taxation Avoidance Agreement between India and US, which says that the determination of source of income shall be subject to such source rules in the domestic laws of the contracting state. Which means even though there's a prima facie treaty agreement of giving respect to the tax paid in the other country, there is still a quota of reservation to the domestic taxes. Now the US in their IRS code has also created regulations for foreign sourcing to determine the sourcing of the transaction. So even though the sourcing should be in India technically, by virtue of this particular provision in the DTAA and then by virtue of the provision in the IRC, the source has moved to US in some cases, in cases of sale of some property, such as personal property. So any personal property being sold by a US resident, even though it is sold in India, the source for all taxation purposes would be considered to be in the US. What does this mean to you and me? What is the implication of these wordings? It would mean that the amount of tax that you're paying in India, you cannot take credit for that in the US for these particular kinds of assets. So then why is the DTAA for? It defeats the whole purpose of having the treaty in place. And this leads to one of the biggest capital gains issues. This leads to one of the biggest pain points for US and Indian residents trying to have a capital gains transaction. So let's talk about some tools of tax planning. How can we effectively minimize this anomaly in the taxation provisions? I think the first starting point is value. We need to value a pre-tax planning tool so as to effectively manage these transactions as and when they happen. A lot of times we have clients come over a day after they've made the transaction, asking us to minimize the tax burden of the transaction that's already happened, which is pretty insane, right? Thank you. Once the transaction takes place, it gets a lot more complicated to do it, to plan the tax effectively, and which is why we believe the first starting point is pre-tax plan. I think. So there are two major tax planning tools that I'd like to talk about right now. One is the use of an intermediate holding jurisdiction. We are going to go into greater detail about it in the coming slides, so I'm just going to skip it for right now. The other is recharacterization of the asset as source level. I quickly explain what this means. So if you paid attention to the previous slide, it said that any income from sale of personal property by a US resident shall be sourced in the US. The sourcing rules that move to the US are for properties which are personal in nature. Now, the definition of personal property is very wide and it's very comprehensive. So apparently there isn't much that we can do with respect to the definition. However, what we can do is we can recharacterize the asset from a personal asset to a business asset right at the source level. So the source level in this case would be India right before making the transaction. Again, it gets a lot difficult recharacterizing the transaction once it's already been done. So if we can effectively recharacterize the transaction from a personal to a business asset before the transaction takes place, we can probably avoid all the capital gains issues that we usually face. However, the Indian government is, as you must have heard a lot of things about the Indian government over the last few years. I mean, at one point I was thinking of emigrating from the country just because of the government. The Indian government has been really scrupulous, is the honest word, is it? There has been a lot of discrimination in the past, which has eroded the trust of non-residents with the Indian country and the government at large. Right. This is what all of us feel, which is very true, by the way. It's happened in the past, and we've lived with it for a lot of years. However, I've been moving around the US over the last few weeks and the UK as well. And there's one observation that I've made which has really surprised me, is how little people actually know about the recent changes that are being made in the Indian ecosystem and the Indian economy, which is really beneficial and which is very inviting to non-residents. So let's talk about the new India. So in the past, I am sure many of us here would agree, setting up a business in India, it's probably more difficult than doing the actual business in India. And that's been true in the past. At entry level, there have been restrictions. There have been sectoral limits. The government decides what kind of business you can do, what kind of business you can't do, what are the sectors you can enter, the kind of formalities that you actually need as a non-resident to do bona fide business in India. But it takes me great pleasure to discuss that all of that is in the past. Over the last few months, the government of India has come up with a slew of reforms, and it's completely changed the landscape of Indian business and the Indian ecosystem and the way India is being perceived in the world. So, what are the changes? Let us talk about some of them. The FDI regime has been completely liberalized. India has now become the most open economy in the world. What does it mean that India has become the most open economy? It means that barring a few sectors, a very handful of few sectors, all the other sectors are under automatic rule, whereby nobody needs any permission to set up base and start working in India in most of the sectors. So, in the last few months, there have been a slew of rules and regulations, and I'm going to cover some of the important ones. Let's start with construction, infrastructure. Probably the biggest need in India right now is construction and infrastructure, and probably the biggest value that can be created, not just for the country but also for the stakeholders, is probably into infrastructure and construction. In the past, these sectors were highly regulated. So there was a restriction on the minimum capital that you could bring in. So to start construction as a non-resident, you would need to have at least $5 million as a capitalization just to begin with. You needed to have a minimum square feet area. There were rules on exit. There was lock-in for investors who are non-residents. All of that has been done away with now. So now, say you being a non-resident, you decide to undertake a construction project in India. There are no rules that you need to apply under before starting a business, except for the formation of a company, which any normal resident Indian would do. But if, say, after a few years you want to exit and you want to unlock value, there are no limits after a minimum 3-year lock-in period. So a non-resident can transfer his stake to another non-resident, he can transfer it to a resident, he can part with it, he can plan for the parting in whichever way he wants to. This has been a major change, and not only in the US but also in the UK. When we've been moving around meeting clients, there has been a lot of money that is going into real estate right now in India. Of course, we are going to talk about the real estate opportunities, and we will skip to that later. So, in a nutshell, setting up in India has become a lot easier. The government has become really liberal, and they're not just saying it now, they're proving it with their actions. Let's move to another major reforms that not a lot of people seem to be knowing, but is equally important. So India is one of the biggest R&D hubs in the world, right? Because of our skilled, low-cost manpower, it becomes the preferred destination for every possible company to set up in India, which is great. It employs a lot of people, it adds a lot of value to the economy, it upgrades the skill level of our population. But once the invention is created, it is very conveniently moved to a better taxing jurisdiction. It is conveniently moved and held into another jurisdiction which is more easy to comply with, which has a lot more trust established. With a view to supporting the local economy and obtaining the benefits of technology patent, the government has come out with their own patent box scheme. Now, the patent box scheme is a popular concept. It's there in some of the developed economies of the world, UK, Ireland, and so on and so forth. This is the first time something like that has happened into India, and it's a very recent change. It's happened in the last few months. So what does it mean? It means that if you have an Indian patent and you want to exploit that patent, meaning you want to add value to somebody's life and get a consideration in return, the government is only going to tax you at 10% on the gross royalty that you're earning from these rights. No questions asked. It's a completely transparent scheme. Now that is a huge advantage if you want to, if you have a patent which you have developed in India, you want to keep in India, or you developed a patent somewhere and you want to move it to India for exploiting it in the Asia Pacific region. India becomes a very convenient location for doing that now. And the royalty that we are earning from it, 10% is on global, worldwide royalty that is being earned from that patent. So it is not just Indian income. Any money that you can earn from it across the world is going to be taxed at a subsidized rate of 10% only. Now this helps a lot of technology firms, and we all know how much of the technology industry in the US Indians are supporting. In fact, over the last 8 days, I have been asked at least 6 times whether I belong to the technology industry because, well, I'm from India and I'm traveling to the US for work. So, this is a major shift. If somebody has a patent, somebody has a development, wants to move it to India or has it in India and is considering moving it outside, they don't need to do that anymore. So there are some conditions that you should be aware of for this particular scheme. One is that the patent must be registered in India. So there is a Patents Act 1970 under which registration is mandatory. But let's face it, you would register your patent anyway globally. So this is mandatory. Along with that, you need to be an Indian resident. Now, when I say Indian resident, what does it mean? It means that you need to have an entity which is incorporated into India, or you need to be an individual living in India. So we need to set up an entity which holds the IP through which whatever money we are generating gets taxed at 10%. Some major opportunities. So as I mentioned, infrastructure and construction, they are probably one of the biggest areas of investment that we see flow from US non-residents into India. And we see a lot of US and UK based funds setting up shop in India just to invest exclusively into the real estate space. We are actually doing some structuring, we will get to that in some time. Manufacturing. So everybody must have heard about the Make in India initiative. And by now, we are very sure of how serious the government has become for the manufacturing boost. I was actually flying into Heathrow about 3 weeks back. And all I could see, instead of Coca-Cola ads, I could see Make in India ads. And that just showed me how much the government is serious about bringing about awareness and promoting this initiative. So if you want to set up a manufacturing facility in India and you decide to do it in a region which is developing, you get a lot of initiatives from the government, you get a lot of subsidies, you get a lot of assistance. It's just a great place to be in, manufacturing in India. And of course, there's no FDI rules associated with it, so you're free to set up anytime, anywhere. Health and medical, a growing population of 1 billion people. What could be bigger than medical and health facilities? India is still a very evolving and infrastructurally underdeveloped when it comes to medical and healthcare. And there is a lot of opportunity to be found there. Food and food packaging. So most of the Indian economy still runs on agriculture. Agriculture is a huge part of the Indian economy. In fact, when monsoons don't go properly, the entire economy takes a hit. Therein comes food packaging. If you're looking for a great opportunity in India right now, I would say go for this, food packaging. And then there's technology and e-commerce, which we discussed about in light of the patent scheme and e-commerce. So I recently read somewhere that India has the third largest number of technology e-commerce companies in the world. So we've established that India is a great place to be in right now. The government is very serious. There's some genuine money to be made, genuine value to be unlocked. How do you enter the Indian market as a business person? So you can set up shop directly into India. You have a company over here, or you set up something of a subsidiary, an Indian subsidiary of your American parent. All that is good. However, if and when you want to sell your business and unlock value from that part of the business, this is going to be a tax inefficient strategy, just setting up directly into India. So what we do in international taxation parlance is we set up an intermediate holding jurisdiction. So over the last 10 years, 75 to 80% of Indian investments have gone through either Mauritius or Singapore. So can anybody tell me why do we do this? Why do we set up a holding company in a tax efficient jurisdiction? Anybody? So if you are selling business, if you're selling the Indian entity here, you're going to have to pay a lot of capital gains. There might be stamp duty in some cases, depending on the kind of business you're operating in. It's just a very tax inefficient scheme. If you set up a holding company in a tax efficient jurisdiction, you can just transfer that holding company if you want to transfer your Indian business. Doing this, you can save enormous amount of capital gains, you minimize your taxes, and it's a lot smoother. This is why we use and we recommend in a lot of cases to set up a holding company in a tax efficient jurisdiction. Of course, the decision of the jurisdiction is very business specific. Like for example, the example of the real estate fund that I was talking about, you cannot set up in Netherlands. If it's not a very efficient jurisdiction to set up for real estate investment into India because of the treaty. So it depends, it's very industry specific, but the three major jurisdictions that we'll talk about today is Mauritius, Singapore, and Netherlands. So how many of us here have heard about the recent changes in the India-Mauritius DPWA? Anybody? So I'll give a little background on the Indian-Mauritius Treaty. India had a long-standing treaty with Mauritius which said that any capital gains arising out of Mauritius, arising out of India from by a Mauritius company is going to be taxed in Mauritius. So the source is going to be Mauritius. And Mauritius has, can anybody guess the percentage of capital gains in Mauritius? It's 0%. So effectively, you're saving a lot of money. However, which is why Mauritius is probably was the most preferred route into entry into Indian market. However, the Indian government has been trying to renegotiate the treaty to plug in the loophole for the last 10 years. And finally, earlier this year, they were able to renegotiate the treaty, whereby now the capital gains, the source of it is going to move to India. So apparently, the Mauritius Treaty has plugged in this loophole, and that would imply that Mauritius is no longer a preferred destination, right? No. The treaty that has been renegotiated has been done with respect to equity. If you want to set up something with debt, Mauritius is still a very good route. So let's talk about the Singapore-India DPWA. Now, Singapore, as we all know, is a very developed country. A lot of economic activity is happening. They are taking away a lot of our people. It's all around a pretty good city. Most of the American multinational companies who want to do work in Asia Pacific, they set up shop in Singapore. So usually they set up an Asian subsidiary in Singapore, and they associate the brand rights and the royalty rights for the entire Asia Pacific region to Singapore. And then from Singapore, individual strategy to enter into different countries is charted out. For example, entering into the Indian markets from Singapore. Now, Singapore had a very similar clause. Capital gains still has a very similar capital gains clause as it was in the Mauritius Treaty. However, the Singapore Treaty has a clause which links it to the Mauritius Treaty, which says that if by any chance the Mauritius Treaty is renegotiated, the Singapore Treaty will lose its right of capital gains sourcing. So what is the current status of the Singapore Treaty? The current status is that the treaty is being renegotiated, but there is no definite wording on it. The countries are in talks, and we don't know how long this is going to go on. So there emerges Netherlands. It's a preferred destination. It's got a very sound treaty network around the world. So if you are a company operating in more than 2 or 3 jurisdictions, Netherlands would probably be a good place in a lot of cases to set up. Now, choice of entity. Now, let's talk solely at an India level. So you're sold in India. You want to set up something in India. What do you do? Do you set up a company? Do you set up an LLP? By the way, does anybody know what an LLP in Indian context would be?
No liability. No liability or
Yeah.
little liability.
So how is it different from a company?
No, they share their risk and
Share the risk? What do you mean?
this people start together a business in LLC and they share their risk.
Okay, I'll explain. Right, thank you. Did somebody say?
Private limited company in India? Is that equivalent of LLP?
No, so a private limited company and LLP, they are two different entities. So in the last 5-7 years, the government has come out with an LLP entity, which is a crossover between a partnership and a company. So firstly, let's do this by the way of elimination. So I'm going to talk about a partnership firm and why you should never ever set up a partnership firm in India if you are operating out of the US. So a partnership firm in the Indian context would mean unlimited liability, which means that if you are doing business in India under a partnership firm and somebody sues you, which I'm sure being in the US you must be very aware of. If somebody sues you, they can claim rights on your entire assets, even on your personal assets. There is no limited liability under a partnership in India. So I never advise any of our clients to do a partnership. So then it leaves us with an LLP versus a private company. So an LLP is somewhat of a partnership. It is suited for either infrastructure projects or it is suited for as a holding entity. LLPs are easier to maintain. They have limited liability. They are much less expensive to form and to maintain. However, for a literal business operation, I would not advise an LLP because every time you have a policy change, you need to update your LLP deed rather than a company which just needs to pass a resolution and file that resolution. So when you compare a company with LLP, if you have a bona fide operation, where there are 2 or 3 joint venture partners, you should definitely set up a company, even though it is a little more expensive to set up. And then there's a one-person company. So these companies can really be helpful in holding assets, which we are going to discuss in our next slide. So let's talk a little bit about capital structure. So you want to invest $5 million. We want to invest $5 million, right? How do we do it? Do we do it by equity or do we do it by debt? Now, India has no thin capitalization rules, meaning there is no limit on the amount of debt that you can bring into a company. So you can have a ratio of 90% of debt versus 10% of equity. Now, what are the advantages of it? The advantages are that when you're paying interest on the debt, that's a tax deductible expense. So you can reduce your tax liability by a lot of margin, and you can as well as repatriate some of the money by setting up a debt structure. I think I'm just going to run through this quickly because we might be a bit short on time. The legal risk exposure, it is a really interesting point which I feel I'm obligated to share with everybody. So there has been a company law change. There was an earlier Companies Act 1956 and now there's a Companies Act 2013, meaning any company that is now incorporated in India has to be incorporated under 2013. Now say one of your subsidiary companies gets sued. Along with that, your company is going to get sued too because you would have directors in there, your directors are going to get sued, etc. And the matter is taken to an international court. So you are paying expenses on lawyers, you are paying legal expenses, there is compensation, there's a lot of risk exposure. How can you reduce this risk exposure? How can you effectively minimize this? Now, the Companies Act 1956 said that no company can reimburse its directors for any legal liability. Now, Companies Act 2013 has become silent on this issue. So, unless otherwise mentioned, everything is possible, right? So, this is what we call gap filling, whereby if you add some important clauses in your memorandum of association, you can take a lot of security against that risk exposure for litigation. Would you? So I'll just cover this point maybe, and then we'll skip the slides. So I was mentioning about the immovable property, and I mentioned that I'm going to come back to it. So it's time to revisit it. Most of our NRI clients, most of the people from individual people from outside India, they want to buy property in India. Not only it helps them plan for the retirement maybe, but also good investment too. And so I'd like to discuss about what are the most effective tax planning ways of purchasing immovable property in India. Now, when you are selling an immovable property, so if the purchase is with an intention of selling it in the future, there are two major implications. One is the local duty, which are stamp duties and so on and so forth. And the other is income tax on capital gain that arises on the transfer. For effective minimization, I suggest holding an asset under a company. And if you would reconnect it with my last slide, I mentioned about a 1% company, which is the easiest to maintain, easiest to form, you don't need to rely on anybody, and you hold your company under that. If you're purchasing it for personal consumption, then you can do it as an individual, but I always advise you should probably do it under a company. And then there have been some tax credit rules that have clarified the tax benefits. I don't think we have time to get into that, so I'll quickly pass on to Rachna. Yeah.
Thank you so much, Shashwat. This was a wonderful presentation and a lot of information. I hope you all enjoyed all the tax issues here in India and US. Now, let's get into disclosure program in US. Most of you must have heard here or there about FBAR, foreign bank reporting, foreign asset reporting, but it never clarifies what exactly IRS is talking about when they're talking about disclosure program. So the disclosure program is basically divided into two main aspects. One is income, the other one is asset. Let's cover the income part first. What IRS says, any US person, if they have any income generating outside the US, they have to report on the US income tax return. When the US person basically means US citizen, resident alien, now some of the non-resident alien, when they file their US taxes, they have to pick any worldwide income they have. The US citizen, the category is divided between three. Number one is the US citizen, which is very simple. By birth, if you're a US citizen, or by law, US citizen. The next broader category is US resident. The US resident are defined by the IRS Code Section 7701B, US resident by green card test, green card holder, or substantial presence test. Once you are a green card holder, and if you are filing a regular 1040 and you're taking all the benefits as the regular citizens do, you are subject to disclosure program. The second, substantial presence test. As long as you live here for 183 days, and there's a calculation we have to do to make sure you qualify for the substantial presence test, you fall into the disclosure program. US taxes are based on the worldwide income, that's where the double taxation is coming in again. So let's see what are the treaties, most of them Shashwat has covered tonight. US and India do have income tax treaty, where if you have paid taxes on some of those income, you bring it here, you do get foreign tax credit. Now, depending on the nature of the transaction, the nature of the property, there may be some where you don't get full credit based on your US tax bracket on all the credits, but you are qualified to take those foreign tax credit. The next big question is always is it mandatory or is it optional? It is mandatory. There is no way around it. I wish there was one, but there is no way around it. If you are a US citizen, if you're filing a regular 1040, you are required to report all that income. Now, the income that you generate, you have to report on 1040 based on the nature. If it's an interest income, dividend income, Schedule B, if you have a capital gain, some of the capital gain based on if it's a movable property or immovable property. The example of immovable is a real estate. Movable is your stocks, securities. So based on the nature of the property, you may qualify not to report at all on US taxes. Now, usually people ask, what kind of income do I need to report? So there are two types of income, active income, passive income. Active income basically means where you have performed the services, where you are going to where you have performed the services and you have generating that income, which is wages, tips, salaries, commission. The passive income are the one where you have invested your money in an account, but you don't have any material participation. Money just sitting there and you are generating revenue. The examples are interest, dividend. So those income are called passive income. Now, the passive income could be recurring or non-recurring. The recurring passive incomes are dividend, interest. You have money sitting in the bank account, and every month you get an interest. You get your bank statement, which shows how much income you have generated. So those are called recurring. Non-recurring are if you have an asset, you sold your asset. You don't sell your asset every month. Those are called non-recurring, and that's where you use the capital.
I'm sorry, Rachel, there's been some requests to be a little louder online.
Okay. We okay now?
Yeah.
There you go. Okay. So the passive income also includes rental income. It's a recurring, but if you have a rental property outside the US, you are required to report that income on the US taxes as well. Now, we have already talked about the first aspect, which was income. I'm going to skip this. Let's cover that for a second, and then we'll go into detail on the F part first, and then we'll come back to that. So for financial accounts reported by US taxpayer, if you have an account anywhere, financial interest in any account outside the US, IRS requires you to disclose that along with your tax return or as a separate filing. As a separate filing is called foreign bank account reporting, FBAR, which is short term is FBAR, and I will be referring to FBAR. The first one is the Foreign Account Tax Compliance Act, which is called, the short form is FATCA. Based on how much you have in the foreign account, you may be required to file both. They are mandatory. Again, it's not voluntary. The program itself is voluntary, that you come up front, you report it to the IRS before they find out. Yes, we will be going into that detail on that too. So before IRS finds out, and if you come up front and report it, you are in compliance. And that's what they are looking for, voluntary disclosure. For US person, it's not, US person includes the entities as well who are under the US tax laws or URL, which has been formed in US here. Only US person who has financial interest in any financial institution outside the US are required to disclose those accounts. The foreign definition for the foreign is, again, outside the US, also include physical location of the account. For an example, if US institution have a physical presence in India, then it will be considered as a foreign bank account, even though the institution is based in US. So if First Tennessee Bank, even though it's a US-based bank, but if they have a physical presence in India and you have money in there, you are required to report that account. Now, in order to make it easier, when you are required to file a file, what elements you need, they have broken it down into 4 categories. I'm going to talk in detail on this and then we'll go back. The 4 elements are, number 1, you have to be a US person. Number 2 is the financial interest. Number 3, it must be foreign. Number 4, the cumulative bank account balance has to be more than $10,000. If you are missing any one of those elements, you are not required to file that. Now, the main, when you were asking about the $10,000, this is the limit for FR. We will be covering for FATCA as well. Now let's move on to the first element, which was US citizen. As I discussed earlier, depending on your citizenship or residence status, that's how they consider you if you are required or not. No matter where you decide, if you are a US citizen and if you live in any other part of the world, you are still required. So if you say, oh, I had my citizenship, but I have not lived in the US for 10 years, I'm not required to file, that's the wrong answer. You are still required to file. So it doesn't matter where you reside. Now, the second element of FR that we're talking about is the financial interest. What does it really mean? What it means when we say financial interest in any account. Financial interest basically means a US person. That includes US entity and resident alien and citizen. Holds an interest or a title on the account outside the US. It also means if you have an authority on the account in outside the US, even though your name is not on that account, but if you have a power of attorney where you can write the checks, you are still liable to report that account. For an example, if you have an account where your parent they are the account holder, but you have a power of attorney or authority to move the funds around, you have to report it. And if they are holding an account, you open an account when you were in India, you moved here, but you still have the account and they are holding on behalf of you, you are required to file the FR, not them. The third element is foreign accounts. Once again, the word itself explains anything outside the US is a foreign account. The last element, the $10,000, what I have explained is the cumulative balance. It's not one account I have 8,000, another account I have 8,000, but I don't have 10,000 any account, I'm not required to file. No, the cumulative balance they're talking about. If you have 5 accounts, in each account you have $2,000, as soon as you reach the $10,000 limit, you are required to file that year. So, but at the same time, Ira said, if you move the fund from one account to the other account, you don't double count it. So if you had an account A, where you have $8,000 sitting in, you close that account, move that fund to the other account, and now account B has $8,000. As and you have no other accounts, you're not required to file it because your cumulative balance was only $8,000. Take the same scenario. You had another account C, where you have $12,000. Now because you have reached the 10,000 limit, you have to report A, B, and C, all three accounts. So A account, you're going to report $8,000, account B, $8,000, account C, $12,000. So it is going to be based on the maximum value of the account during the year. It's not about at the end of the year, on December 31st, what was your balance in the account, is the maximum balance. Again, when we are talking about the foreign currency for an account, we have a conversion rate. We have that piece too. So the IRS suggests you take the conversion rate at the end of the fiscal year. So dollar versus rupees. It's going up and down and up and down. It has been consistent for the last couple of years, but if you remember way back when, we had $40, 40 rupees a dollar. So for an example, suppose in 2016, in June, the rate was 40 rupees. By December, it went to 60. We're going to use the conversion rate at December 31st, which is 60, not 40. Now, if there's another interesting thing, if you have more than 25 accounts outside the US, IRS is not asking for the details. So you better have more than 25 accounts. What they say, you check the box. You let them, there is a form, the form that we fill out, there is a box. If you check, I have more than 25 accounts, you don't need to give them the details. IRS asks you to maintain the records with you and make it available upon their request. So you keep it with you, you don't have to give it to them. Now, another big question we always get, what account do I have to report? So the account that we have to report is a bank account, mutual fund, brokerage account, life insurance policy which has a cash value to it. So these are the accounts you have to report. What account do I don't report? You don't have to report any personal assets. If you have any personal assets sitting there, you don't have to report. You have gold, you have silver, you have, I don't know, gold biscuits sitting somewhere in India. You are not required to report that. You have real estate, collectibles, those are not in the compliance program. US person also means the US entities. So if US LLC, where I'll give an example, husband and wife formed an LLC, and the LLC has an account outside the US, LLC will be filing the FR, not husband and wife on their personal taxes. So just make sure that if you form it, do it on the corporation or LLC name and let LLC file the FR. Now deadline for FR is June 30th. There is no extension, it's a separate filing, it's not a part of your taxes, and there is no, so IRS says if you don't have information ready, just because India has a different financial year than we do, and if you don't have the information readily available, just report whatever you think it is. And then later on, amend it, but don't miss the deadline. If you miss the deadline, there will be penalty. Not filing the FR is not an option. If you don't file, they say, I'm sorry.
You say it's voluntary and
If you do it by yourself, if they find out that you have not filed, then you get penalized. So the penalty of not filing is up to 100,000 or 50% of the account balance, whichever is higher. I'm going to cover a little bit really quick. I know we're running out of the time, a lot of information here. The FATCA is more advanced version of FR. This is where if you have more than 75,000 for a single filer or 150,000 in merit filing joint, you have to file another form called 8938. That is a part of your tax return. That is not a separate form. Now, if you remember, your taxes are due April 15th. FBAR is due until June 30th. So FBAR, they say, oh, I don't have the balance, I'm going to file on June 30th, and I'll be done. But on June 30th, when you start to file the FBAR, you find out you had more than $200,000. You did not do that. when you file the tax return. So you're gonna go back and amend your taxes and fill out the Form 8938. And again, this is mandatory. There is nothing you can say, oh, I didn't know about the rule. Ignorance is not an excuse. So again, there are significant penalties on that as well. Is there a quick difference between the FATCA and the FPAR? So what is the solution for all that? Be in compliance. Go ahead and file it. Start now. If you do it by yourself, volunteer come up front, there is no, they will let it go. But if they find out, they will take the penalty. If the IRS finds out, they will take the penalty. If you find out that you were required to file 8938, go back and amend your return now. You have 3-year window to amend your return. And then once you report everything, you can easily transfer the money from India to US because you have already reported everything. Now, I am going to give the floor back to Shashwat, and just going to cover one last topic. India has signed up with the international government where Indian banks will be reporting voluntary all your information, bank account, bank balances to the IRS. So they just signed last year. So even if we don't do it, our Indian bank will be reporting it to the IRS. So
We're gonna get our money.
thank you so much for your patience. Now we have 10 minutes to answer any question you have.
So we have responded for question. You said, bank accounts, does that include, mutual funds?
Thank you everybody around the world for joining us. Any queries can be, I'm sorry, just a sec. Any queries can be sent to shashwat@artosran.com and rka@avrcpa.com. And you can check out www.artosran.com or www.avrcpa.com for more information. Thank you.
Yes, please. My question is, you said